My learned friend will answer, Malas. At the end, that will take us 10, 15 minutes. He'll cover that. But let me, Malas, come to my first list. Let me stick to my sequence. Just an aside, Malas, all that was done in the last 10 minutes was reference to everything but the whip. The only issue relevant is whip. Your Lordship would be asked to turn parliamentary and party-based democracy on its head if you were told that whip is not issued by the political party. What your Lordship has shown just now is totally irrelevant and red herring because it is intimating to the Speaker and the House that in this House, my leader is so-and-so. That is a communication between those in the House communicating with the Speaker. Speaker has to know whom to communicate with. It is no communication of the party with its members. That's the whip. And that the party issues, the party decides. But that was apart. We'll come to those rules. So this is completely irrelevant. It cannot be anybody's case that in the context of a whip, the party, the political party is to be ignored and the legislative party is to be looked at. Now, but leave that aside. Let me go in my own sequence first. I'll come to that. Well, as your Lordships ended before lunch, Mr. Sibbal finished with a flourish, about democracy. Let me just start with that. Well, according to my respectful sir, I'll come 7, 8.
You follow the same note, Dr. Singh?
Now, on the note, I have an apology, little bit of a mix-up. My note came to me in the morning. I corrected it and sent it back. Somehow it didn't go through. So they have filed by mistake the old note, which I had not corrected. Luckily, sitting here, I found it, and I corrected it. It has been, we've got hard sets, it's been emailed, but your Lordship's uploading is in your Lordship's domain. So, the court master was told all this, so your Lordship may have to either upload it or have the hard sets. Because there's a mix-up, the uncorrected note came here. I made many corrections in that. So, this is A7, Lordship call it A7. And my learned friends have all got it, pre-lunch.
Old one remove kar dena.
This will be in substitution, I'm sorry.
Remove kar dena.
This will be in substitution of A6. A6 is the wrong one, the earlier one. Let me just summarize orally and then I'll come to the note because it will be much easier to follow the crux of my submissions. May I start? Your Lordships have got one, either the hard copy or the soft one, whichever your Lordship is using.
Same, Same. What is the change?
No, there are a lot of changes. Your Lordship may just take this one.
Starting is the same paragraph.
No, starting, but there are changes. Lordship may chunk the other one, otherwise Lordship will be confused with the other one.
So just comparing, but it
no, there are changes. Lordship may just tell them, your Lordship's assistants to delete that earlier A6, that's all. Otherwise there may be some confusion. There are whole sections which are added, etc. That's all right, your Lordship will use this first. Now, the first submission, and I'm not going to follow this sequence, allow me to oralize. My first of my 8 facets is something which is repeatedly fallen from your Lordships, and yesterday it fell directly from my Lord Justice Narasimha. That your Lordship is concerned about democracy, majority becoming less, or your Lordship use the word overwhelming numbers going this way or that way. This connects with that. Mr. Sibbal has answered in one way. I'm now giving your Lordship a different facet. Well, my submission is that your Lordship has to go back to the origins of the 10th schedule. And first point under this head is that the 10th schedule has 2 components, not only one. One is a prohibitory negative code. It's a negative code. So a negative code is what you should not do. Violating a whip, voluntary resignation, cohabiting with other people, etc. But there is also an affirmative, positive part of that code. And what the 10th schedule does is to strike a balance between the negative and the positive by a constitutional amendment. It is my respectful submission that it is vital for your Lordships to give effect to both negative and positive in letter and spirit. Because your Lordship is actually implementing the Constitution. And some of the arguments of the other side have bordered on suggesting that a mere, I'm using the word mere advisedly in comparison to a constitutional text, a mere symbols order will be competing with a constitutional text. That would be completely anathema to all known principles. What are these two codes, Balas? The negative code is that you, in a nutshell, I'm just saying, in a nutshell, I'm oversimplifying. You will not voluntarily give up membership to an A and you will not violate whips to one B. Just in a broad summary. What is the affirmative permissible activity? You are entitled to dissent only within that permissible zone. Otherwise, why enact the 10th schedule, Malas? Prior to 85, you didn't have the 10th schedule. You had Jungle Raj, which you called Ayaram Gayaram sometimes, but then you can also justify that in the name of free speech, free action. What you did here was you allowed a zone of activity, permissible, affirmative, but you cannot say that I will go beyond that permissible and thereby violate indirectly the negative code also. What is that permissible activity? The affirmative code of conduct. One is if faction or a split till the 91st Amendment. They gave you an escape route, advisedly, consciously. That has gone. It was there. So the Constitution famous thought that along with a negative code of conduct, so as not to stifle you completely, we give you an escape route, exit route of faction or 1/3 or whatever it was called. Second, merger. Third, and this is actually the most important part of 10th schedule. Elections, barring a few cases, in the days of 1960s, etc., there used to be a very strong, large number of independents. Independents have now dwindled. The statistics show, even then, in terms of 545 Lok Sabha, you had hardly 30, 40. But independents commanded a coordination. My father also got into Lok Sabha on an independent party-less ticket. So I know at that time, Mr. Nath Pai, so many people. But today, even then, party democracy was, everything was based on party. You got a ticket and you fought and you won because the party projected you as its candidate. That is now, much, much truer after the 60s, 70s onwards. Today, the number of independents compared to the 60s would be a fraction. So it's party-based democracy. You like it or not, it's not for anybody to question. We've chosen it, but there's nothing perfect. Some people say US is better, some people say European, but this is what we've chosen. And now, this third balance.
Third point is what? What is the point?
One is
split is permissible, merger
second is merger. Third now.
The third point.
Third comes with the light of what I said just now. The whole idea of the 10th schedule is resign and recontest. That's what is stopping you from doing. You enter the door through this door and then you retain your ministership and seat while exiting through the other door. Sorry, not permissible. Resign, have the courage of your conviction. Now, you are a very vocal freedom speaker. You have the courage of your conviction.
Which Justice Jeevan Reddy referred to in that extract.
I'll be dealing with some of that.
It was not in the context of the 10th schedule.
But I'll be dealing with that. Some judgments have referred to it. I'm going to suggest, because this is the core question my Lord Narasimha asked, my Lords asked earlier. What do we do when an overwhelming set of people want to express dissent? 9 10, let's say 9 out of 10 minutes. Let's take an extreme example. How do we balance and countervail these two competing balances? The 10th schedule says you can go thus far in balancing, not further. Whereas if you are so much for free speech, courage of your convictions, this is a rotten party, I can't say, resign and contest. Recontest, what is the problem? Then the fourth is the exemptions. Apart from merger, there's the exemption clause, condonation, whatever. All that is given there. Now what we have to see is that if a constitutional amendment balances the prohibitory with the affirmative part, you cannot find an excuse to circumvent the prohibitory part by going beyond the 4 avenues of the affirmative part, now only 3. Faction is gone. Now, let us take this further, because that's your Lordship's query. I'm sorry, there is a fifth one. I forgot. There's a fifth one. I'm now breaking it up. There is a fifth balancing on the affirmative side. You are so concerned about free speech. You are resigning is one. Or you absolutely hate where you are. You go to the election commission and start your para 15 proceeding that I am the real party. But you do that without indulging into the prohibitory part. That's well as keeping the sanctity of the 10th schedule. Now I'm addressing the core dilemma of my lords. Let me develop it, Balus, in a minute. That's also a statutory remedy, lower than constitutional. So the fifth is, Balus, now actually only four because that faction is gone, split is gone. So four. The fourth would be file a complaint to the election commission, say, look, 9 of us are standing here, we are the party, recognize us. Till then, don't do any prohibitory activity. The election commission will or will not recognize you and is subject to challenge. What does this do, Malus? This maintains the sanctity of the 10th schedule and maintains the negative and the affirmative parts of the 10th schedule. What does my lord normally prefer? A option I give your lordships which reduces the other option to vanishing point? Or an option which harmonizes both? Elementary principles tell your lordship by 1,000 cases that your lordship prefers the harmonization approach. Elementary common sense shows that my learned friend stand reduces the 10th schedule to vanishing point. It is as good as a dead letter or a repeal. Which is better? The answer is self-evident. Now, Malas, here, just see, Malas, how this dead letter vanishing point arises. You don't resign with the courage of your convictions to fight another election. You don't go to the election commission till much later. Almost a month, just under a month after 21st you went to Guwahati, 19th you go to the election commission. 2 days before a month is ending. You don't seek condonation. What you do is, Balats, what I call a 3 steps novel procedure to annihilate the 10th schedule. It's a 3-step novel procedure. Step 1 of which is disable the speaker by giving him a mere notice. So, the man can't touch you on the 10th schedule. Just see, my submission of harmonization versus vanishing point. Step 2 of this sinister 3-step novel procedure is to forward resolutions parallelly to the governor, who in turn makes it the basis of a trust vote direction. And the final step 3 is the act of being sworn in as Chief Minister.
Sorry?
The act of being sworn in as Chief Minister. With another party fully supporting, in whose lap you were in Guwahati. Now, I'm not on the... Just kindly consider. You don't follow the affirmative part which gives you play in the joints and leeway, flexibility. You don't resign. You don't merge. The most important, interesting point is you don't merge. Just see for a minute that B, poor B. If you are sitting in their lap and they are supporting you, at the last minute, instead of them becoming Chief Minister, they make you Chief Minister. What is the problem with merging? So, you say to hell with the 10th schedule, it gives me an escape route, I'll ignore it. I'll go to the 3 steps. And the language, without opening it, where his original political party merges with another political party, and he claims and any other members of the original political party have become members of such political party, or as the case may be, of a new political party formed by such merger. Well, this is directly snooking a nose at the 10th schedule, which is a constitutional creation. It is, I'm sorry to use colloquial, it's actually saying, look, to hell with the 10th schedule, we have made this 3-step procedure. Why on earth could you not recontest, resign, merge, or the 4th one? Condonation, I'm not getting into, that's another one. Go to the election commission and file a complaint then. On 21st, instead of Surat and Guwahati, Why did you not file the election commission? So this is the first answer. This is one of the best answer at least I can give to the direct question, but there is a consequential answer further ahead. I am putting it against myself and trying to answer because I put this question to myself and Lordship asked it yesterday. Now, a possible argument will be twofold. That is no argument because how it works in actual law, a fact is not an argument against me. If the law is a prohibitive and a affirmative, then you jolly well follow it. That's the object of creating a constitution. But now I'm giving an answer against me even though it doesn't arise in law. The answer is, what happens, Mr. Singhvi, if between me, that is they, applying to the EC and doing these things which Mr. Singhvi is advising them to do, the speaker disqualifies you. I'm putting it bluntly against myself. His first answer is, so what? Why was the 10th schedule created, Balas? Is the speaker doing something unknown to law? But there's a better answer. If he disqualifies you, there is full judicial, this is on the basis wrongly. There is full judicial review. No, you can't, because your lordships can't find a solution to everything which the Constituent Assembly, the Constituent amending people did not make. What is this answer? That what do? I will be disqualified. Well, jolly well you'll be disqualified because the 1985 framers gave this power to the speaker. Is the possibility of an abuse ever the test of the power or its existence? Can it be? Otherwise, how will your lordship decide anything? Yes, that phrase comes from Rajnarayan versus Indira Gandhi. Possibility of abuse is not the test of power. Give that citation.
Hindustan judgment. One Hindustan construction, some judgment is there.
Also Hindustan construction.
Abuse of power cannot be the.
Your lordship should judge everything. Oh, what will happen? What may happen? But that's not the question. Here, and your lordship is talking of lesser cases. Here, the constitution was amended to give this power. And the apprehension is, I will not go on 21st to speaker, to EC. I will go to Guwahati because I'm scared of a disqualification. Now, let us look at the second. I'm giving a lot of extreme examples against myself. You have a full review possible. My review is much more truncated. It takes 1 year for me to get this hearing before your lordships. Your review is immediate on a wrongful decision against the speaker. And your lordship knows Kyoto says, after final decision of the speaker, you will get a stay of that. You can't get a stay while he's deciding. You can get it afterwards. Of the disqualification also. Only a quia tibet is stopped.
You're comparing that with what?
With the fact that if you don't do this and stay and make the 10th schedule a dead letter and install a new government on the basis of ignoring the 10th schedule, that is much less reversible by sheer passage of a few days than your right to challenge. Today, what is the whole argument? It's a scrambled dead, it's a fake accompli. Your lordships can't reverse it. It's 1 year down the line. That's the real argument today. That's the argument we are facing. Now let me give your lordship another bizarre example against myself. These are not normal examples, but I don't know of except a very few number of cases where you have the courage of conviction to resign and recontest. That resignation is impeded. It happens. There are 2 or 3 judgments we have, but normally, let me assume against myself that I resign because of my high standards and my resignation is not accepted by the speaker. That's the worst I can assume against myself.